My name is Henry Noa, and I'm a part of an organization by the name of Counter. We are here tonight to share with you additional information from what we shared with you several weeks ago. Several weeks ago, we had shared with you how important law plays a role toward acquiring or reacquiring sovereignty. In this presentation, I will define specific law terms, their applications directly to sovereignty. Before I begin, I would like to thank those individuals and groups who have contacted us at Counter and have invited our group to share with them the presentation, Sovereignty, the Perspective According to Law. It is also encouraging to know that people are beginning to realize the application of law to sovereignty is very important. Interesting enough, the basic questions such as what is sovereignty, what is a sovereign nation, what is law, and what is authority were the questions most people had difficulty understanding. So I will begin this presentation by defining those very questions. Remember that these definitions are taken directly out of law textbooks such as Black's Law Dictionary, 4th edition, Bouvier's Law Dictionary, and the Law of Nations. The first question that I'd like to answer is, what is sovereignty? You know, people are confused right now as to exactly what sovereignty is. So, taken out of the context of Black's dictionary, sovereignty is the supreme, absolute, and uncontrollable power by which any independent state is governed. Supreme political authority, paramount control of the Constitution and frame of government and its administration. So obviously, when we're speaking about sovereignty, we're speaking about total independence, having control of our laws and being able to conduct our political authority under these laws and governed by this control. According to laws of nations, sovereignty is, government is that political authority which directs or orders what is to be done by each member associated in relation to the end of the association. So it's obvious that everyone who intends to get involved with sovereignty has to understand his particular responsibility and his role toward acquiring sovereignty, understanding how government should function. These are the key important facts that people should understand when pursuing sovereignty. Another question that was brought up was, what is a sovereign nation? Well, according to laws of nations, a nation which governs itself by its own authority and its own laws, which does not depend on any other nation. Its rights are in the natural order, the same as those of every other nation. Interesting enough, here again, we are told that we're supposed to be governed by our own authority and have our own laws. Well, at one time, a great nation by the name of Kingdom of Hawaii existed and had exactly its own laws and its own authorities. It is important to understand that law establishes one's foundation so that a nation can build upon this foundation and establish exactly what direction they should be headed for. After reading A Sovereign Nation in the Law of Nations textbook, what caught my eye was its rights are in the natural order. Unless people understand what the natural order is, it makes it difficult to proceed, because at a time when this Law of Nations book was created, it was done in 1742 and translated from French to English in 1758. Nations were constantly fighting each other and conquering larger nations, conquering smaller nations. It was important that nations started to agree upon certain laws to preserve their sovereign identities. Well, the Law of Nations explains it quite clearly. What is the natural order? And by understanding the natural order, it establishes a nation's identity and it preserves that identity even in the event of an overthrow or a takeover by a larger country. I'd like to get into the natural order, but it takes time and explanation. Some of the law terms that I'll be covering will lead us to understand what exactly is the natural order. You know, some people have addressed us and have commented to us about law, you know, and how law is very susceptible to accepting some of the facts, you know, and some of the judgments that are being done today. Well, we need to understand the differences between some laws and what is law. Well, let me define to you what law is according to Black's Law Dictionary. Law is that which is laid down, ordained, or established, a rule or method according to which phenomena or actions coexist or follow each other, that which must be obeyed and followed by citizens, subject to sanctions or legal consequences, is a law. So it's obvious that over a period of time, certain laws are laid down and they are established and ordained. This becomes the fundamental principles that are applied between conduct of nations and states, between judicial decisions, and these have to be understood. Without understanding the parameters involving law, it makes it difficult for one to stand upon the foundations of law. Another thing is authorities. We need to understand what is authorities. Well, authorities is citations to statutes, precedents, judicial decisions, and the textbooks of law. What it basically states is, without having the textbooks of law as its fundamental foundations, it makes it difficult for us to build upon. Modern society is based upon laws. It's based upon fundamental laws. These all establish an organized jural society, which makes it possible for the countries or the nations in the world to work together. Well, we specifically focus upon sovereignty and how each group can play a role, or each nation plays a role towards each other. And this role is based upon the laws this role is played upon international laws. And international laws is known as that of law of nations. When you look into the Black's Dictionary, you will find that law of nations is the definition that Black utilizes as public laws. These are the laws that regulate the conduct between nations and states. So when you realize that there are laws governing nations and states, it makes it a lot easier for us who are seeking sovereignty to now refer to this law textbook and to utilize the law textbooks and its applications. Of course, there are other law textbooks available and other definitions that apply to sovereignty. Two of the definitions that I'd like to share with you is what is de jure and what is de facto. Well, de jure is what is lawful by right, legitimate, and by justice. De jure gives a status to a nation that had existed and had the perfect right to acquire this status through its existence. And what is de facto? De facto is in fact, in reality, and actuality. These two law terms, they apply directly to nations or states to determine their past, present, or future statuses. In the event of Hawaiian sovereignty, we had an existing government, and this existing government had a de jure status. What's interesting to note is how is this status applied when you look into its definition? Generally used in contrast to the term de facto, in that de jure connotes as a matter to law, while de facto connotes as a matter of conduct or practice not founded upon law. Well, it's obvious that de jure, according to law, has more concrete foundations than a de facto government is. As I mentioned earlier, de facto is in fact, in reality, and in actuality. Well, in fact, they exist. In reality, they conduct themselves, and they actually pass laws, they conduct themselves, they utilize the court systems. Well, the textbooks of laws also define what is a de facto government. A de facto government is one that maintains itself by a display of force against the will of the rightful legal government in overturning the institutions of the rightful legal government by setting up its own in lieu thereof. This definition defines the situation right now that we're in. Here we have a de facto government who has admitted its de facto status but through public law 103 and 150 by declaring that it had illegally overthrown the rightful legal government. The question is this: how do we utilize these law terms? Well, this utilization is a part of the natural order that was mentioned in a sovereign nation. It also applies to several other law terms, and those law terms pertain to perfect rights and imperfect rights. A perfect right is one that, according to their action or scope, is clear, settled, and determinate. According to the law of nations, a perfect right are those which carry with them the right of compelling the fulfillment of corresponding obligations. Well, we need to understand what rights do we have to compel these fulfillment and obligations. It is clear to me that the law of nations explains this actual process, and we need to learn about how this law of nations actually apply to this process, because an imperfect right is vague and unfixed, cannot so compel the fulfillment of corresponding obligations. Now, is it possible for a nation to acquire a de facto status and inherit imperfect rights versus one who has a de jure status and who has the perfect right to compel what is a fulfillment of an obligation? Well, the obligation is clearly stated in 103-150 that we, the de jure government, have a right to repossess what is rightfully ours. Now we move to a perfect obligation. What is a perfect obligation? It is one recognized and sanctioned by law, one which the fulfillment can be enforced with the aid of law. So here we have the law that was set in Public Law 103-150. And we also utilize this law to enforce the fulfillment of our perfect rights and our perfect obligations. It is important to understand that these law terms all apply to the natural order. And this natural order can be clearly understood with the further studying of the law of nations, and how if a nation did not submit to another nation or other men, it has not given up its independence and freedom. This is clearly stated in the law of nations. Well, we, 103 years old, meaning the Kanaka Maoli, we have an opportunity to learn the law and apply the law so that we can make it happen according to the usages of law. All I can share with you is this: law does play a very important role in sovereignty. And I'd like to share with you that without the law, we wouldn't be able to establish this foundation. And all it takes is each one of us to understand our responsibility. We at Kauna are encouraging groups to contact us so that we can come and share our entire presentation, dealing exactly with the laws and how it applies to acquiring sovereignty. I'd also like to encourage individuals to attend some of our seminars. You can contact us at these numbers, 396-9379, and ask for myself, or you can contact us at 833-8069. Thank you, and aloha.